Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Live Law, where we bring you the latest developments from all courts across India. Let us start. The strength of judges at the Supreme Court has increased to 32 as Justice Ujjal, Bhuyan and Justice S. Venkata Narayan Bhatti took oath as judges of the Supreme Court today. 2 more vacancies are now remaining. At the Supreme Court, Justice Bhuyan will have a term till August 2, 2029 and Justice Bhatti till 6th May 2027. Justice Ujjal Bhuyan was appointed as a judge of the Guwahati High Court in October 2011. He is currently the senior-most judge of his parent High Court and has served as the Chief Justice of High Court for the state of Telangana since June 2022. Justice S.V. Bhatti was appointed as a judge of the High Court of Andhra Pradesh in April 2013 and is the senior-most in his parent High Court. He was transferred to the High Court of Kerala in March 2019 and served as its Chief Justice since 1st June this year. There is a new update on the infamous case of premature release of former Bihar MP Anand Mohan, who was convicted in the case for mob lynching of Gopalganj District Magistrate G. Krishnaiah in 1994. He was sentenced to life imprisonment but was released in April this year after serving 14 years because of the remission of sentence granted by the Bihar government. As per the remission policy of the state of Bihar, persons convicted for murder of public servants on duty were not eligible for premature release until they completed at least 20 years of sentence. But this bar was relaxed by amending the remission policy this year. A petition was filed before the Supreme Court challenging Bihar government's decision. In May this year, the Supreme Court bench comprising Justice Surya Kant and Justice J.B. Pardiwala had directed the state government to file its counter affidavit and produce original records of documents which led to the granting of Mohan's remission. The state government has now filed the counter affidavit defending the early release of the former MP. In the affidavit, at the very outset, objection has been raised with respect to the maintainability of the petition, as it submits that there is no breach of fundamental rights of the victims or relatives, as the issue of remission is between the state and the convicts, and that the victims and relatives do not have the right to interfere in state's remission policy framed under statutory or constitutional provisions. The affidavit further submits that as life convicts guilty of murdering the general public are considered for premature release, the state decided to take a positive step to do away with discrimination on the basis of status of the victim. The punishment for murder of general public or a public servant is same. On one hand, the life convict prisoner guilty of murder of general public is considered eligible for premature release, but the one guilty of murder of a public servant is not. This discrimination on the basis of status of victim was sought to be removed by the government. Finally, the affidavit submits that the remission policy provides for a comprehensive and rigorous process with sufficient checks and balances for the consideration of a case for premature release. The matter is listed for 1st August in the Supreme Court. Stay tuned with us. A significant development comes from the Madras High Court in the Senthil Balaji matter in the cash for jobs scam. Justice C.V. Karthikeyan, the third judge to whom the matter was referred after a split in the division bench of Justices Nisha Bano and Bharat Chakrabarti, has ruled in favor of the Enforcement Directorate. Settling the conflicting views regarding the power of Enforcement Directorate to seek police custody of the accused, the Madras High Court has ruled that the central agency was entitled to seek the custody of Tamil Nadu Minister Senthil Balaji in the money laundering case over the alleged cash for jobs scam. On another important issue raised in the matter, Justice Karthikeyan aligned with the view of Justice Chakrabarti, thus excluding the period of treatment undergone by Balaji while calculating the period for custodial interrogation. However, Justice Karthikeyan left it to the wisdom of the division bench to determine the first date of police custody and the days for which exclusion should be granted. The Supreme Court today stayed a judgment of the Karnataka High Court which struck down certain provisions of the Karnataka Education Act in relation to the powers to regulate the fees and appointments of private unaided schools. A three-judge bench comprising Justices B.R. Gawai, J.B. Pardewala and S.V. Bhatti passed the interim order while issuing notice on a special leave petition filed by the state of Karnataka challenging the High Court judgment of December 2022. The High Court had found that the provisions would adversely affect the rights of unaided schools and struck them down, observing that in case of unaided private schools, maximum autonomy has to be with the management with regard to administration, including the right of appointment, disciplinary powers, admission of students, and the fees to be charged. In another update, the Supreme Court today issued notice on the petitions filed by Aam Aadmi Party leader and former Delhi Deputy Chief Minister Manish Sisodia seeking bail in the cases registered by the CBI and ED in connection with the alleged Delhi liquor policy scam. A bench comprising Justices Sanjeev Khanna, Bela M. Trivedi and Ujjal Bhuyan also issued notice on the application filed by Sisodia seeking interim bail to allow him to meet his wife who is suffering from illness. The court will consider the plea for interim bail on 28th July. The bench was hearing two petitions filed by Sisodia challenging the decisions of the Delhi High Court to deny him bail in the cases being investigated by CBI and the Directorate of Enforcement. While CBI is probing the allegations under Prevention of Corruption Act, the ED is handling the money laundering case under PMLA. The Supreme Court has issued notice in the plea filed by Shiv Sena Uddhav Thackeray Party MP Sunil Prabhu seeking a direction to Maharashtra Legislative Assembly Speaker to expeditiously decide on the disqualification pleas pending against rebel Sena MLAs led by Eknath Shinde. The matter was listed before a bench comprising CJI D.Y. Chandrachud, Justice P.S. Narasimha and Justice Manoj Mishra. The court issued notice returnable within 2 weeks. The disqualification petitions against the rebel MLAs were filed by Sunil Prabhu, the Shiv Sena party whip appointed by Uddhav Thackeray in June last year after the MLAs revolted against Thackeray. The notices of disqualification were issued by Deputy Speaker Nirhari Zirwal in the absence of the Speaker. A special court in Bengaluru has dismissed the application filed by nephew and niece of former Tamil Nadu Chief Minister Jayalalitha seeking to release her property and assets seized by the authorities in the disproportionate assets case registered against her in 2004 in their favour. The applicants had claimed that since Ms. Jayalalitha had died before pronouncement of the judgment by the Supreme Court, she was not having stigma of conviction. They contended that order of abatement is nothing but a clean chit to her with regard to all the charges framed in the case. Thus, they being the legal heirs were entitled to get all the properties. The court said that the Supreme Court had ordered to abate the case against Ms. Lalita only with regard to punishment portion and not with regard to the order of confiscation with respect to the properties seized and attached. Court said, even though petitioners had been declared as legal heirs to succeed the estate of Jayalalitha, but under the facts and circumstances of the case, it was not possible to hold that they were entitled to get the seized properties. Court also noted that there was no segregation with regard to the properties held by Jayalalitha and the other accused persons. You already know that Supreme Court in 2017 had convicted AIADMK General Secretary Sasikala in the disproportionate assets case registered in 2004. The court had upheld the trial court order and set aside Karnataka High Court judgment which acquitted Jayalalitha and Sasikala and others accused in the case. And lastly, an update on an issue regarding religious conversion. In this case, the FIR lodged by informant Himanshu Dikshit stated that 90 Hindus had congregated at Evangelical Church of India in Fatehpur for converting to Christianity under undue influence, coercion and luring them by playing fraud and promise of easy money. Accordingly, the government officers had interrogated the pastor Vijay Masaya, who disclosed that the process for conversion was actually going on and that even patients admitted to the mission hospital were being converted. In this case, the Supreme Court today extended interim protection from arrest to the Vice Chancellor Dr. Rajendra Bihari Lal and Director Vinod Bihari Lal of Sam Higginbottom University of Agriculture, Technology and Sciences in connection with the case. It was contended that the applicants were not named in the FIR but had been implicated at subsequent stages on the basis of statements given by two interested witnesses and that the investigating officer was being biased against the applicants. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us.